A warm greetings to all. I am here presenting the renowned senior advocate Supreme Court of India, Sudh Markandeji. In this episode number 72, sir will deal with the direct evidence of demand and giving of a bribe. Ever since the Constitution Bench on 21st November 2022 reserved the judgment in Neeraj Datta vs. State GNVTD Criminal Appeal number 1669 of 2009, we have been tracking this batch of 12 appeals. Please tell us, our viewers, how the case arose.
Neeraj Datta's case, that is Criminal Appeal number 1669 of 2009, had come up for hearing before a bench comprising of Justices R. Bhanumati and R. Subhash Reddy on 28th of February 2019. When the court noticed that except in P. Satyanarayana Murthy versus District Inspector of Police, 2015-10 SCC 152, the Supreme Court has taken the consistent view that in corruption cases, direct evidence of demand and giving of bribes is not necessary. For various reasons, what happens is that complainant may die, some vital witness may die, so direct evidence may not be necessary. But because of the dissonance of this view created by P. Satyanarayan Murthy's case, the bench framed the following question for reference to
Yes,
a
sir.
larger bench. So, this is the question: whether, in the absence of evidence of complainant or direct or primary evidence of demand of illegal gratification, is it not permissible to draw inferential deduction of culpability oblique guilt of a public servant under Section 7 and Section 13(1)(d), read with Section 13(2) of the Prevention of Corruption Act, on the basis of the other evidence adduced by the prosecution? So, this is the question which was framed. As you have said, there were 12 criminal appeals that
Yes,
were
sir.
heard by the Constitution Bench, consisting of Justices S.A. Nazir, B.R. Gawai, A.S. Bopanna, V. Subbala Subramaniam, and Madam Justice B.V. Nagaratna for a number of days, and the judgment was reserved on 21st November 2022. And no doubt we were, as you said, tracking the judgment because it involves a very important question affecting both the prosecution as well as the accused.
So, what has the Constitution Bench held?
The Constitution Bench answered the reference in the affirmative. That is, it reiterated the law already laid down in most of the judgments except P. Satyanarayana Murthy. In effect, the Constitution Bench has reiterated that direct evidence of demand and giving of bribe is not necessary. In other words, it is permissible for the court to draw inferential deduction of culpability of a public servant under sections 7 and 13(1)(d), read with section 13(2) of the Prevention of Corruption Act. So this now continues to be law unless, it is upset by even a larger bench. I must tell our viewers that even while the reference was pending before the Constitution Bench,
Yes, sir.
another criminal appeal, 261 of 2022, K. Shantamma versus State of Telangana, was heard by a division bench of Justices Ajay Rastogi and Abhay S. Oka. And relying on P. Satyanarayan Murthy's case, they allowed that appeal of the accused on the basis of the view which has today been disapproved. So no one pointed out, why will accused counsel point out? But in all fairness, they should point out.
Yes, sir.
And The prosecution also did not point out that reference is already pending before a constitution bench.
Yes, sir.
So, as I'm writing this answer to your questions, the full judgment has also been put on the website. So, I did not have the benefit of seeing the judgment because it was put quite late, or maybe I didn't see, or whatever. So, it has now been put on the website of the Supreme Court of India. And since this is a very important question,
Yes, sir.
and particularly relating to the Prevention of Corruption Act, I would like to analyze today's judgment and have another detailed episode
Of
put
course,
out
sir. Of
there
course, sir.
on
Of course,
our
sir. Definitely, sir. We
uh,
will have a new episode on this, sir.
on our channel.
Yes, sir. Yes, sir. We will have a sir, episode on, and we will analyze on the judgment given by the Supreme Court.
So that is all for today.